Hey all, here is a replay version of the most recent live stream Q&A on all things Social Security that occurs every Wednesday at 1 p.m. Eastern Standard Time. So this is with all of little silences carved out of it. So I hope it's an easier listen for those who are doing the replay versus being there live. And we'd love to see you live. So feel free to pop in. Bye-bye now. All right, I think I figured that out. Can you guys click comments now if you can? I think what happened was something on the YouTube side, but let's see. Yeah, it should be okay. Let me go back. So I'm wondering if you guys were trying to, oh, it's not started yet. Upcoming, it is started. All right, let's see. I'm just seeing if I can figure this out. Mike's in the house, 6,000 feet. Hi, Mike. Do you guys have any questions? Yeah, that was like a little bit of a train wreck earlier. And I'm like, hey, since there's no questions. And then I looked and it looked like in the, see, I'm in StreamYard and then it goes all the way to YouTube. Before that ever happens, at some time between scheduling it and in StreamYard and it going live, you have to go in and tell YouTube, no, this is not for kids. It doesn't mean kids are banned from it or anything. It's just not designed for kids. But if you don't say that, then it restricts comments, I guess. And I guess it's to protect kids because of some wonky, occasionally get our obnoxious person in here, and you don't really want kids to be exposed to anything stupid. Not that we see a lot of it, but on occasion. So that's what it was. I had been in there and I changed it probably yesterday, and I think I forgot to hit save. Yes, it's all on me. Nobody else. I can't have anyone else to blame. Mike, do you have any questions or anything? I see James Kibble in the house. James says, hey, my ALJ did not apply the Title 20 subpart N. Well, you have to be a little more specific than that. Why don't you spell it all out for us? Does that mean you got your denial already? Because that's the only way you're going to know whether he applied or not, right? Did he address it? Did you say, I'm not doing it? And what in particular did you want him to do, right? What do you think there, James? And you're talking about wage credits for veterans? Is that what you're doing? That's not really going to change. Well, that's like a really, recall, that is like a really puny thing. It affects really more so what your benefit's going to be by a teeny tiny bit about if it actually applies. And I think you had to be in the military between 1940 and 1956. So I'm not sure. You'd have to be more specific, James. I don't really know. Deb Lindley. Oh my gosh, your ears must have been ringing, Deb. James, if you want to get more specific, feel free to pop it up there. Deb, it is so good to see you. Your ears had to be ringing yesterday because I was like, gosh, hope she's okay because I haven't seen you in many weeks, if not a few months, right? Still trying to hold on. Well, hold on. Yes, please. It's good to see you. I think about you a lot, Deb. James is working on it. Okay. So it's something. So James, it is something about that little teeny tiny little thing, extra work credits. That would only be, honestly, it's only going to affect you if you don't have work credits and you're somehow, you think you need them, and it's not going to change the disability finding, right? Unless for some reason it tips you over to an extra credit, gives you an extra quarter that you were lacking and it was case, affecting. So that's the only thing I could think of. That would be kind of relevant. Like if you were saying, if you were not insured and that little extra amount would tip you over into the credit you didn't earn for certain things, maybe because he was finding that you weren't disabled during a time you were insured. But, other than that, I don't really, and that would be so rare. And I'm trying to think, are there anyone, I don't even think that should be more for retirement too, because those years that it says it applies to, those people, none of them are under the age necessary. You have to be under full retirement age by like a good year to even apply for Social Security disability. So maybe you're referring to something with regard to retirement, James? Is that what you're doing? That would be for the after full retirement age and beyond. James says, it says the Appeals Council is using these rules to affect the VA benefits on Social Security. 441360. Let's see. 4413. Did I say 60? Did you see? What did I just say? Let's see. 1360. It just goes pop in there. VA pension or compensation payable. Before we determine and certify payment, if we are informed by the VA that a pension or compensation is payable to you before we determine and certify payment of benefits based on deemed insured status, we compute your monthly benefit or lump sum death payment based on the death of the World War II veteran without using the wage credits discussed in 1350. After we determine and certify payment, so that would be, I'm not sure how that affects, how does that affect you in particular? Because you're getting credit for earnings from being in that military era, right? it can increase very little. I mean, it's honestly, it seems pathetically small to me, but I suppose it made the difference between having credits or not. So let's say your income was so low and never met the 40 quarterly credits you need over your lifetime to get retirement. And adding those things would pop you over the edge. That's a few $100 of earnings tops. You have to be really close. Then I could see it. That just seems so rare. Usually people have easily met the 40 earnings credits requirement for retirement. I mean, that's 10 years of part-time work over your 40-year, working years lifespan. So I don't know, James. Yeah. I mean, you're just trying to figure out if you're going to get an extra, $2 in a lifetime. I mean, it's really small, James. It is so puny. It's almost like, I don't know, it's really puny. Are you saying, James, yeah, you met the 40. So this isn't, I mean, it's certainly not going to make a difference between you being found disabled or not. So I think you're talking about retirement and you're trying to see, should I be getting an extra couple bucks? Well, that's fine. And if the judge didn't apply what was applicable, then the appeals council is going to flip them. And if they didn't, and you're very sure and your attorney's sure, then you would go to federal district court if it's worth your time. I mean, I don't know how much money you're talking about. I don't know that it actually makes a big, quarter here, quarter there. I don't know. It doesn't seem like it would be very much. Danny, yeah, I was like, the one time I'm on and we can't speak, I'm back. No, it was just me and my sticky fingers and not hitting the save button on the not for kids section. So it's all good. It's all good. But anyway, definitely plop in your questions, guys, because I am serious when I say I'll be out of here because there's so much stuff I've got going on right now to get done. And it is not even the hearing. Those are always done in advance. But I've got hearings coming up, and those are the ones that are like in their mandatory hustle time with last updates and tweaking briefs and all that good stuff. And it didn't help with a little bit of internet sketchiness during the storm either. Yeah, James, I know it's confusing. It certainly is. But, I give you credit for giving it the old college try because, if it is a few more bucks, let's say it's $20 a month, I think it would be worth it, unless you're like uber wealthy. I don't know. $20 a month for the rest of your life. That's kind of nice. Let's see. Anybody? Any takers? I'll give you guys a couple more minutes and then I'm going to say adieu again. Oh, sunflowers in the house. If you have a professional license but can't work since one doesn't know if one will be approved, does it look bad if you continue to keep it current but aren't working? I don't think so. Sunflower. But and I'll tell you why in a minute. But you say can't work since one doesn't know if one will be approved. That inadvertently suggests that one isn't working because they're trying to be approved. It's not that they're not working because they can't. And remember, Sunflower, people can work part-time under SGA and still have a claim going forward. And as long as your medical evidence is really strong and shows that you could not be doing this or anything else full-time, right? So you just got to watch, if you're in a profession that pays a lot per hour, you got to keep those hours down to next to nothing. But I don't think it looks bad to keep a professional license up. It's because everyone who's a worker and a diligent person over their lifetime, no one wants to be on disability. And a lot of people will keep their license because they might be able to do something part-time while disabled if they don't fully recover, or they're hopeful they're going to fully recover, but right now they're not. And SSD is not a permanent. There's no need to prove that you're permanently disabled. You just have to prove you're disabled under the rules today for that mandatory 12 months. So keeping a license because you're working hard to get better, I think that's a good sign. It's a good sign of diligence, best of intentions, and all that. So I don't think it's bad at all. John TB says hello, and I say hi back, John. Andy Griffith is in the house. Hi, Stephanie. I know taxes are not your thing, but do you know if like H&R Block is familiar with amortizing back pay for 3 years? You'd like to think so. You have to. I would just ask them. I need a tax preparer very familiar with the Social Security back pay handling method to attribute them to the proper year's tax repercussions in this current year. So they have to have somebody. I mean, they have to have accountants in there, not just tax preparers, right? Speaking of tax preparer or accountant, I'm trying to get an accountant for the two estates, small, nothing major, guys, of my husband's beloved family members that passed in these last few years. And they're both out of state and we don't really know anybody. And, we need taxes done for a trust that is going to be, it has been largely dispersed. It's got to get the last things, the taxes paid, if any, and then like disperse the rest of the beneficiaries of the trust. And then one trust that will be ongoing, that the one person that it takes from the trust, theirs has to go into another trust because they're not able to handle their own monies. So that trust lives on forever. But trusts are entities that have to pay taxes if they make a profit. There wasn't really much profit here because nobody was really properly investing the money. Everything was happening so fast. And then like each estate, I believe, has to have its own tax return, even if they didn't increase in value from the time of death to the time of disbursement. So I'm hoping on I got a referral to someone who's out in California, but I think they can do hopefully all these other states because we're in Pennsylvania. One person's in North Carolina, one person's in South Carolina. Yikes, this is a real pain in the rear. Just want to tie up the loose ends. Patriots in the house. Can the ALJ have a medical witness at hearing if they didn't tell you there was going to be one testifying? Probably. I mean, maybe not. You can object to the hearing notice because it didn't say it in there. If because there is actually like if we ever to object to something in the hearing notice, that's a particular kind of letter that goes out. It's not typical, but it's there. It's one of the labeled things we can upload. So I would think perhaps that could be objectionable. Doesn't mean he's not going to continue the hearing with his own medical witness, but it might be something that would be appealable later. I can't say for sure. It's never crossed my path in that way. Sunflower says it came out all wrong. I know what you meant, but I just wanted to make sure other people were aware, Sunflower, that, John says, if I retire at 62, how can I get health insurance? That's like saying, how can I go out to dinner every night? Can you afford it? Go buy it. That's all. We all work to pay for what we need in our lives. If you retire at 62, you do that usually with an eyeball towards, can I afford to retire at 62? Or do I have to wait till at least 65 so I can get Medicare? And then remember, of course, there's premiums with Medicare and there's co-pays and deductibles. That's another thing to think about. Can I afford to retire at 65? Or will those things blow me out of the water if I'm on limited retirement income because I don't have a lot of retirement income? And should I be buying a supplement policy on top of the traditional Medicare premium? Because I know I'm going to have many, many doctor visits because I'm not the healthiest person. And that will cover all the copays and deductibles. Getting one of those SUP plans, it's an extra expense every month, but it's kind of like a form of relief. I mean, when my mother was here, we got her, it was one of the top SUP plans. It cost an extra couple $100 a month, but she lived with us so she could afford it. She wasn't worried, had to pay, commercial rent someplace and Uber drivers or fill her tank with gas or anything like that. So when you're staying with family, like when the family stays together, when the parents get older, a lot more can be afforded because there is not double the rent. There is not this, that, and the other thing. It's not two households being made up. So she could have that. And what was nice about it, John, was anytime I took her to the doctor, she got covered by any doctor that takes Medicare. And then the SUP plan kicks in all those 80-20 splits. When you got to pay 20% of a $1,000 bill, that's, $2,000. So it covered all that. And I don't think it covered like $200 deductible or something like that, which I think they've gotten rid of the one plan that did because I just feel like the G is the G that's gone and she is the F or something like that. But it all depends on, what your situation is. If someone has very, very low Social Security and they're retiring at 62, they might be, you got to look at your state. Maybe you have state welfare insurance, like the Medicaid, that you can look into. But, when we choose to retire early, it's really no one else's business to decide how we're going to pay for the things we want, whether it's health insurance or pay as you go or groceries, or I like to go out to dinner twice a month at a fancy restaurant. Like that's what we adults have to figure out for ourselves, right? Sounds harsh, right? You're not used to it. But it's just reality. Think about before there was even Social Security. People did this for hands, it's only in the last century, very recently that this kind of socialized Social Security came into play to take that responsibility to some degree, away from each adult. And John, if you were disabled from working, and that's why you want to retire at 62, file for SSD. Because then if you get it, you'll at least get Medicare after 24 months of back benefits or forward benefits. So that could speed it up a little bit. And it will also save you from taking early retirement at 62, which is going to decimate your benefit for the rest of your life. It's like a 35% cut. So do you want to take it 62 so you don't have to work, but you're going to living on 1/3 less? Yikes. Everyone's got a different story. I know mine doesn't go that way. If I get disabled and can't work, I will definitely file for SSD and hopefully prevail. But yeah, I just it really depends. Like some people are like, I only have $8,000 a month. How can I afford health insurance? Well, you best try. Then there's people that are living on $1,000 a month. And they're the ones that are probably going to be able to get Medicaid, the welfare health insurance. So you just got to do your due diligence there, okay? And that Medicaid is state involved. It's not really federal involved. James says, I just saw on my SSA page that it says the appeals council is using these rules under. No, because I think it's an automated rule. It's like the calculations. It's just automatically used. Like it's not really something you have to fight about. So no, I don't think it's an ALJ error, James, because the ALJ doesn't decide how much you're getting. He only decides if you're disabled or I don't know what your issue was that you were appealing about. I mean, you're talking about the appeals council. So you obviously went to an ALJ hearing. I don't know what were you appealing? Did you file for SSD and you lost and you appealed it, which would be the standard, the most normal. And in that case, this part has really nothing to do with you. The whole subpart N. Justin Zane's in the house. Caribbean greetings. Yeah, you're in the warmth. I'm in like 2-3 feet of snow there. Justin. Deb Lindley's talking to John. Let's see. Catalytic Converter says, I just got my CDR determination. Finally, 7 months later, my disability is determined to be continuing. I'm so glad for all of your help during this process. Thank you. It's been a nightmare. Yeah, I know. It brings on a lot of stress, doesn't it? I can only imagine, but I'm very glad for you. That's what typically happens, by the way. Your result is what is normally what happens when people are just doing the disabled thing, following with their doctors as always, and it's not the kind of condition that gets better. Degenerative things, like as we get older, that's actually, I hate to say it, to our benefit with CDRs, because the degeneration doesn't really improve. It just, things get worse. Hopefully not very fast. Hopefully they're stable. As it says, would you be able to remind me what percentage of cases actually prevail? I don't know how many cases actually prevail, but I do remember a waterfall chart from a few years ago. I mentioned this recently. They said 38% overall. That's the people that have really strong cases and the people that have crappy cases. 38% went on initial. And I think it said of the ones that appeal when they're denied, so the other 62% and 15%, if they all appeal, which they don't because people just give up, then 15% of them will actually get it flipped. And the rest that decide to appeal that go to ALJ. And I think, what do we say? What is it, like a 50% average at ALJ now? Or I don't know. I don't even know what it is. I have to, if I ever get a second to breathe, I will try to find an updated waterfall chart. Also, if I turn 54 in June, is that a grid hurdle? It's 55, not 54. So either way, you need to treat, do what you have to do. Sacrifice here, sacrifice there if you have to. If you need to get physical therapy and the copays can be really stinky, try to find a way. Even if it means working a part-time easy job, just making $300 a month to pay for the treatment you might need to prove your case. I'm speaking generally here, but sometimes, guys, that's what we got to do. If we're not invalid in bed and we have enough money for all these copays, then sometimes the answer is we'll do something genteel for 5 hours a week, making $75, which is about $300 a month, just for the sole purpose of having the cash to go pay for the treatment you want for your body that will produce the evidence also for your case. Just an idea. It's kind of like you have to think outside the box. I mean, if it's not a work that is inconsistent with what you say you can't do, it's not going to hurt your case. But the big thing is you need the treatment and you need the evidence. And they're very tough on 50 to 54-year-olds. I mean, they're excruciatingly tough on the under 50s. But the 50 to 54-year-olds have been for a number of years now. It almost seems like the SSA bends itself into a pretzel to say, you're limited. You can't do more than light work. Of course, that doesn't mean you're disabled. It just means you're limited. There's plenty of jobs that are light. And that's where they're nailing the 50 to 54-year-olds. They're not agreeing that they are limited to sedentary work, in which case then they would win, assuming they can't do the prior work and they can't transfer those skills due to perhaps mental health issues, anxiety that they're treating for. Justin says, how long until I run out of track on my claim? What is track? I have no idea what that means. You mean your DLI? If you've been working, let's say, you got all 4 credits up to, let's say someone stops middle of 2025 and they made over their $8,000, $9,000. If you got all 4 credits for 2025, you'd have 26, 27, 28, 29, 30. The end of 2030 would be when your DLI, if that's what you mean by track. It's date last insured. Very, very important date for anyone claiming. Oh, inheritance is here. Got a complaint? Why am I not surprised? Inheritance. Amazing how the Appeals Council website is broken. Can't change a thing. Engineering obsolescence is our government norms, and they usually are very antiquated. You have 60 days, 2,000 characters are a joke. Oh, no. That's not a joke. 60 days is plenty of time. Appeals counsel appeal takes 30 seconds, and you do not need to put 2,000 characters in there. You just need to say the judge erred and this matter should be remanded or reversed. That's all you need to say. They have the duty to then go look at everything and see where he erred. They know how to do it. I don't stick a brief in the thing that where you're saying I'm appealing and here's why. The brief, if I'm going to do a brief, is going to be separate. And then you click the button about I want an extension to get in a brief, and then bingo, you have 25 days. But that part is not the joke. I've never had a problem with the website. It's never been broken for me in 21 years. There's other things that could use improvement, but that's just not one of them. In fact, it used to be that you couldn't even appeal it online, and they had a fax number. And half the time it didn't work, and your fax didn't go through, and you're running down on that 60-day deadline. And you could mail it to them. Then you have to go to the post office and do it certified mail because you got to make sure you have proof that you did it in time. Blah, blah, blah. You want to talk about a pain? This is much better. You get a view that says you appealed. You print that. You save it. You know you have your proof that you appealed in a timely fashion, and it won't be canceled then. So it's definitely better than it used to be by a million miles, but it can always use improvement. So John says he's at 62. So John, I think you're saying at 62, your reduced amount would be 2,000, which means your full amount, if you waited to 67, would be about 3,000. Is that correct? And you're willing to consider taking 2,000 a month for the rest of your life rather than waiting 5 years and taking the 3,000, which of course will go up with COLA, but they both will. Yeah, that's a choice. Some people have a variety of reasons. Maybe they have an ill family member. They want to spend more time. Maybe they don't feel so great. Now, I think if it's something where it's physically or mentally, you don't feel great and you don't feel like you continue without losing your mind, or I think it's one to consider talking to a professional about filing for SSD. If your physical or mental impairments are leading someone to want to retire at 62 when they're really financially would be better off holding out, because a lot of people can prevail for SSD, and you can file for early retirement and file for Social Security disability. You take the early retirement because you need the money. If you're not working and you don't think you can go back to work and you need the money now, it's the risk that you might get stuck with that amount forever, but that's a choice you make. And you file for SSD at the same time. It's totally legit. It's done all the time. You might have trouble getting an SSD lawyer because now you're already taking your Social Security, so there's going to be nothing for them to get paid with, or very little, so that might be a problem. But you could do it. I mean, you can file for both. And I would definitely suggest doing that if it's in any way related to your medical condition or pain or symptoms. It doesn't cost you anything. And then the other alternative, of course, as I said before, John, is if you're going to collect at 62 and take that permanent hit, you could still work and make a little money. You can make quite a bit of money at 62, exclusive of no disability case, and still work while you're taking a 62. There is an earnings cap, though, because you're claiming to be retired, so you have to be largely retired. And the only forward-looking downfall of that whole picture is, what are you going to do when you can't do that extra job? Now you're 70. You took the 2,000 a month. Now you can't do that extra job because now you really just can't, or they're hard to come by or whatever. And now you're stuck with the 2,000 a month without the extra earnings that you are making at 62, 63, 64, 65. So it's all these different scenarios, I think, it behooves us to look at. So Justin says his DLI is December of 2029. So that's your track then, Justin? John says, what is happening with affordable health? I don't know. You have to go talk to those people. That's not me. I suppose as soon as they get rid of the affordable health care package, that could be a start, because it definitely made things unaffordable. And Harry says, funny how on day 4 you go online and manage to get an office appointment on day 62 of your appeal. What are you talking about? There is no such thing as day 62 of your appeal. Well, technically, I suppose there is, because you get that 5-day little window. Hello, all. I got a fully favorable decision from my December 17th hearing. Found out last Thursday. Yeah. Did we talk about this last week, Fan? Or had you not? Yeah, if you found it. Oh, no, we wouldn't have, because we were on Wednesday. That's awesome. That's awesome, awesome, awesome. Later, Inheritance. Have a good one. You're welcome, James. And me says, hi, Jen. Hi, Stephanie. There is some SSA portal where my lawyers are supposed to view the evidence for my second ALJ hearing. Of course. That didn't happen the first time. Is this portal newer? No. It's been around for 15 years or more. I'm not sure. I'm trying to think when I first got in. Before 2010, I think. No. We can now get into it long before we go to ALJ hearing. We can get into it now on initial and recon. That started 2020. 2020? Yeah, where we could see the medical evidence on initial and recon. It was one of the biggest, most awesome changes. And we've been wanting it for years, because otherwise you couldn't see anything until you went to hearing. And then this past June, the administration got some technology in order to let us representatives in the electronic file we have access to see the section A, which is the DDE, the reason for the denial that wasn't, it's not in the other parts of the file. So that was something that they have always withheld, and it never made sense. So this administration was like, yeah, let's put it out there. Now, I'd like to see a couple other things out there too, but it's a start. It's a huge start, actually. John says, I'm in logging and back needs fusion. Oh, yeah. But I'm afraid, John, file for SSD. Did you file for SSD? If you're a logger, you're clearly going to be able to prove you can't do your old job unless you are like the manager sitting on the pedestal up in the nice office, perhaps. Is it sedentary work? But I'm guessing not. So I might not qualify if I don't get the surgery. That's not necessarily true. The fact that you need the surgery and you have perhaps very good reasons for not doing it, including wanting to see how conservative therapies work, certain exercises and physical therapy help strengthen the back so that while it's far from perfect and you got to still do sedentary or even light at your age, you can still prevail. I think you should definitely apply if you have not applied, for sure. Jen Me says, also, I don't have the instructions from the federal judge to the ALJ for the remand hearing. Someone said you get a copy of those instructions. It's just the appeals council order that says we're ordering it back because you've neglected to do A, B, or C. And yeah, your attorneys would have that too. But you were mailed it too, so you should have it. If not, you could get it from the ALJ's office. They'd probably give it to you. You can also get it from the field office, but that's like, let's see. Yeah, Deb is chiming in on John's at $2,000 a month. She said he wouldn't qualify for Medicaid in his state, which I think was Virginia. Yeah, it wouldn't be a freebie. You know, I'm not really familiar, guys. Is there like some sliding scale stuff too, like with Medicaids in some places? Like, well, you can't get full-blown freebie Medicaid, like maybe $1,000 a month person could, but we do a sliding scale, like you pay 10% or, you know what I mean? And then, so it's not a full free ride. A little bit of welfare kicks in. I don't know. Thought maybe that was true in some areas because states can all, you know, they all manage and decide how they're going to do that. Hey, Kevin Johnson from Tennessee is in the house. I think he's saying I did get SSI back pay 25 months, and that made my Medicare come in play as of January 2026. Awesome. Yep. Another reason why you always assert the oldest date that's reasonable as your onset date, even if you can't get paid that far back because of the 12-month retro rule, retro to the date you apply, because it can help you eliminate the waiting period. Eat up that 24 months of back pay that you have to have before Medicare. That's great, Kevin. I'm really glad for you. Deb says, John, you aren't qualified or forced to have surgery in order to qualify for SSDI. He's 62, Deb. Yeah, and I agree with Deb. I mean, they will say fecklessly not go with medical advice. However, surgery is very serious. There's risk of death. If someone has had a surgery before and it just didn't work out that great, or they had bad side effects, that could be, you know, just make sure you just mention it to your doctors, the reasons why. And if you just say, oh, because, I mean, if the doctor says the risks are this, I would say about 50% of people improve, 30% stay the same, and 20% get worse after the surgery, from the surgery. I would almost be like, we discussed the risks and you told me how high they were for not having a successful surgery results. And you and I discussed the risks that would be involved to me, and that perhaps, and I always kind of coach it like this, because never say never, and never say, you know, because it's never really true. Just say, at this time, we're going to pursue more conservative therapies to find enough relief to improve the quality of life as much as possible. And then we will relook at the surgery. That kind of buys you time, and it's not unreasonable, if that makes sense. Arizona Gallagher. Hi, Arizona. Sent an email. Hope I did that right. Is that to us? If it's for representation consideration, you got to go to the website, joydisability.com, and click on the link in the upper left-hand corner for the free eval. All right, and then we can figure out what area you're in and what's going on with it. Are there openings? Is there a wait? Well, John says he just doesn't know what to do. That's about the surgery. I don't blame you for not knowing what to do. But in terms of applying for SSD, if you're no longer working right now, I don't think you should. It doesn't sound like you have a good reason to wait, or a savvy reason to wait, because they take a long time. So get the ball rolling. Catalytic Converter says, I have never been able to get their website to let me log in at all. I signed up for the USPS informed delivery, then picked up the mail anytime I saw something on stay and I faxed them back. It sounds like you have not been able to connect your identity with your account with them. Sometimes that can be if you had a different name on your social than from, say, your driver's license. You can go in person and make sure everything matches up and see, make an appointment to, I don't know how helpful they are, but you should, see where you're missing some piece of information. Either they have wrong information or you forgot to change something. Like sometimes someone will get married, divorced, kept their married name, never changed their social security, and those things are not jiving. And they keep putting in their married divorce name, but their social security still says their birth name. So it could be a variety of things. So you just got to go and find out. Jen Me says, how many days sudden absence per year per month is considered too many absences for any job? The most thing I hear, Jen Me, is more than 1 day a month. And I've even cracked jokes to VEs like, so you're saying that if all you have is 12 unscheduled absences a year, you're fine? I'm like, really? Do they actually give people that many sick days? You know what I mean? I don't know anyone that does, particularly for entry level when you first start. And they will kind of be like, well, it's 1 day a month, but after a certain amount of months, it's probably going to be a game changer. But so long as it lasts 6 months, it's considered a successful work attempt. So if it's, let's say, and nothing's carved in stone. It's not a legal number. The law doesn't define what's acceptable. The vocational experts, due to their hands-on experience, supposedly in the arena that they are experts in, will say, in my experience, the employers will not tolerate more than 1 day a month. I remember a few years back, it was like, they'll allow for up to 3 days, but if you do 4 a month, I'm like, what fantasy land and what unicorn land is 3 days a month not going to get someone fired within a short, month or two? Because I'd say to the VE neck, I go, so you're saying 36 work days a month, someone can just not show up because they're not feeling well, and they're going to get to keep that job? Is that right? And they would be like, you don't really battle with them. You just poke at the obvious. But I've consistently heard at every hearing in the last few years, at least, no more than 1. I mean, we can all argue in our heads that would be unrealistic to expect not to lose a job, but that's just the way it's rolling. So you just got to kind of play with that game. And then in terms of excessive breaks, every 2 hours is permissible because technically a job offers a break after the first 2 hours, then a half-hour lunch at least, and then a 15-minute break in the afternoon after 2 hours. So if you need a break every 2 hours, that is not going to be sufficient to say that you can't do any job. It just won't be, because that is the normal break time. And the reason why they give it to normal is because normal people need it. You don't have to be disabled to need that. Now, if you have to take a break every hour for 15 minutes due to IBS because you're in the bathroom with some issues, and if you can prove it, again, it's very hard to prove what goes on in the bathroom because nobody's got a camera in there. You know what I mean? So it's how you have to always report it to your doctors. And hopefully it starts getting almost organically in those records, naturally a part of those records now on a consistent and ongoing basis over the years. Yeah, so every 2 hours is not considered excessive. It could veer onto excessive if you had to do it every hour. And then again, is it 2 minutes or is it 15 minutes? Is it 40 minutes? Right? Hi, Arizona. I'm sure they got it. So you'll probably hear back. Hey, AF Vet, good afternoon. You too, pal. John says, how about SSI? So here's the problem. You can't get SSI. John has available to him $2,000 a month from early retirement if he chooses to file for it. I takes that into account as to whether or not you need the SSI. When they find out that you have access to $2,000 a month from your retirement, that you can opt to, you have dominion and control over whether you take it. Now you're not poor enough for SSI because that digs into, you're far exceeding the resources and the income, I should say, the income level. Per month, every, dollar for dollar, that's going to get, except for like the first $20 is going to be offset against the SSI. And since the SSI is a hair under 1,000 now, that 2,000 is going to, offset it all. So you would be not eligible for SSI. Yeah. For representation, the consultations are free. It's really the evaluation discussion. First, we look to see if there's going to be, before we waste anybody's time, is there openings in that particular category? And if there is, then they ship it to me and I make the phone call. If there's not, they let the people know so they can, keep inquiring because some of my colleagues are going to have openings. We all kind of vary at different times, where we're tapped out of one, over the top in a particular area. And we have to, keep things available for other people. Yeah, Deb's clearing them up on the SSD. Fan Cave says, I commented on another video. Yeah, thanks for the kind words. To those who are still fighting, keep it up. Mine took almost 6 years and 3 hearings, 2 ALJs, 1 federal district court remand, and then 2 appeals council remands. That is quite the fight, Fan. I'm very glad for you that it's over. I'm thrilled for you, actually. Hi, Deb. Yeah, John, you could definitely just go and fill out that eval. I mean, I'm going to remember who you are, but I always say if you're filling out the eval and we spoke on here and I said, yeah, definitely fill it out, just say what your screen name is in here and just say we spoke on so-and-so date, and they'll see it and they'll send it right to me. They won't even do their initial review. AF vet, oh, well, donation. Thank you. That is very, very kind. Okay, so John says, no, I'm hands-on with the trees, meaning when he's doing logging, he's not the manager sitting in a nice office directing, handling the monies. He's out there doing the physical work. And that is the reason why I think you probably have a good case. So hop on that, John. Okay. And John, you have to have stopped working full-time. That's another thing. It doesn't matter how many years of medical records you have for your back. If it didn't disable you during all those years, it just, didn't feel good, but you're still able to work full-time or SGA, then there will be a limit to that. Guys, we got about 15 minutes or more, and then I got to split because I have that hearing. So just wanted to let you know. Jen says, what would the new ALJ possibly think if I was in a treatment program when my phone hearing comes up May 28th? Like I got on the phone from an office in a PTSD trauma program. I don't know how it would be bad. I mean, if you're in the need of hospitalization at the moment, I mean, you can't be like, I can't go get treatment because I have a hearing. It would be nice if you have a private room in the place where you're treating where you can have your hearing while you're there. But sometimes that's not even possible. And then someone's going to, someone should talk to the ALJ and say, hey, you scheduled the hearing for this. It'd be like if someone got a bad car accident and they're in a hospital. They're not going to be expected to attend the hearing. I think they're going to stay the hearing. But, every case is a little different. So I would, but I don't think it's bad. I mean, it shows that the severity is a decompensation, like someone who's does okay and then decompensates, and then okay and then decompensates. Okay, Fan Cave says some states have a Medicaid spend down, which it opens after a specific amount has been spent down on medical expenses. Would that be a spend down of resources, or do they have some avenue when it comes to the income per month, like what John was talking about? Because I agree with John. If you only have $2,000 a month, and you're alone, maybe you don't have a spouse that's working or bringing in their Social Security, it is very hard to pay the rent or the mortgage, the utilities, the food, and health insurance. It's just, not really doable unless you share a house with multiple people. So your rent is only say $300. Your food, you could probably get away with $100 a week for. I mean, you could do a family of 4 on 100 a few years ago if you really tried. I did it. It was a challenge. And then you have some wonky limited insurance policy. It's not, it's going to be tight. It's definitely going to be tight. Hi, Dimple. Just watching the early. Yeah, that was my screw up, Dimple. But I came back once I figured it out and did a redo. Arizona says, yes to you. My alien situation didn't fit any boxes anywhere, but I'll try again with that too. Thanks so much. Love your channel. Oh my God, that's funny. Dimple says, how long should it take for the local field office to review an application and send it to the state office? Yeah. Sometimes it sits in their inbox for weeks as they get through whoever came in before you. So it's really not carved in stone. It used to be very expeditious years ago. Then the last 3 or 4 years, it got really bad. And I don't even know where it stands now. Has it been improving a little bit? I don't know. You fill out the evaluation that I told you about at joydisability.com. In the upper left, you're going to see a link for a free evaluation. That's what you're going to fill out. That's always the first step to potentially get to me. In this case, I'm going to talk to you because we've been talking about it here. But that is how everyone starts, because I obviously can't call, generally speaking, everybody who wants to talk to me, or else I would never be working, ever. I would just be on the phone all day long with strangers, listening to their issues and directing them. So for this reason, we do have to do a little triage. I already know your situation, John, so just fill that out. Mention that we spoke here, so they see it. My girl sees it, and then she'll just shoot it right over to me. Okay. Oh, yeah, Arizona says, I don't hear your bird today. I know, I didn't bring her in. It was just too many moving parts, and I have to jump into that hearing, and then I would have to take her out, because I don't know if the judge would appreciate having the bird in the hearing. Although I was in a hearing once, judge is hearing from home, the judge's cat walked across. And she's like, oh my God. Cat got into the, whatever room in her house she had her hearings in. It was pretty funny. Limitless is in the house. Mine took 6 months, one first time. My recommendation is shop attorneys carefully. Yes, that is a good idea. I would have used Miss Stephanie, but was locked into a lame, lazy attorney, which I did all the work. And he said from the start, said, don't think you'll win first time around. His intake was lame. Careful. Well, at least you won, so that's good. He probably was hoping you wouldn't win first time around so that there would be a bigger back benefit set for him to get his fee from. I wouldn't be surprised. Thank you, Deb. Yeah, good luck with the hearing. It's one of those 1%ers, guys. Yeah, I'm so glad you're here today. You always have my thoughts, Deb. You know that, right? If you don't see me and I don't see you. Yeah, it's Dimple from Ohio. Very good, John. Van Cave said, the spend down is the difference between the Medicaid income limit and the income. Okay. Oh, yeah, okay. Mine used to be $859, which is the difference between the NH income limit and my SSD. NH, am I having a brain fart here? Also, if working part-time there. Yeah, that would add to it, right? Yeah, I would just look at all those things. So I think what you're saying is, let's say you have a 859 number and you're making 2,000. Do they make you spend down 1,100? And was the spend down, do you have to spend it on medical stuff or can you spend it on anything else? Like when they say spend down of the income, does it mean, yeah, I'm not sure what that means. Okay. I'm interested in it though, because we do need to have some sort of sliding scale. Like, okay, someone who has 2,000 a month, maybe they can pay $100 towards Medicaid versus the guy that has 1,000 that can't pay 100 towards Medicaid. $100 premium for Medicaid is very valuable. It's very, very generous if that's all someone has to pay and they have $2,000 of income. That would be nice to see that become more of a regular thing. And maybe with an incentive to work, such as, 50% of every dollar you earn, only 50% will be counted as income so that people have incentive to still go out and earn part-time, right? They have that kind of 50-50 thing with SSI. So you don't lose your SSI in full for every dollar because they want to incentivize people to get out there and work, improve their life, bring in more money than they would have if they just had the SSI. There's a program called Need Medicaid for employed adults with disabilities. Ah, that's awesome. Yeah, I love it if they give some incentive for people to work because it's so good for them. And it improves their standard of living. They have more spending money, better food on their table. Deb says, I've missed you, Dimple. Hope your RA is doing okay with the crazy up and down temperatures. Yeah. All right, guys, I think we're about through here. If that's okay with you guys, I'm going to split. Thanks for coming back after my little faux pas on the on not clicking the right button and no comments were coming up. I knew something funky was going on, but I wasn't sure what until I went and checked. Anyway, guys, stay safe, stay warm, and I hope to see you at the 12 noon dailies and next Wednesday at 1 p.m. Eastern Standard Time. We should be on our normal time. I have no hearing that day. So, alrighty, I'll chat with you guys later. Bye.